Welcome to the 6th episode in the first season of Justice Center Weekly, a 30-minute video cast from the Justice Center for Constitutional Freedoms. My guest for this show is lawyer Allison Pejovic, who is representing Sheila Annette Lewis. Ms. Lewis is challenging Alberta Health Services' prohibition against persons in need of organ transplants who are not vaccinated against COVID-19. They're prohibited from receiving that life-saving treatment. In other words, no COVID vax, no transplant. Allison, welcome to the show. Let's dive in, and can you please bring us up to date on this heartbreaking case?
Good morning, Kevin. Thanks so much for having me on today. So we've been battling with Alberta Health Services and a group of transplant doctors since 2021, trying to get them to overturn their policies, which require my client, Sheila Annette Lewis, to have 2 doses of a COVID-19 vaccine or 1 dose of AstraZeneca or Johnson & Johnson before she's able to get a life-saving organ transplant that she desperately needs to survive. And we went through 2 levels of court here in Alberta. We lost at the Alberta Court of King's Bench and again at the Court of Appeal. And what we had argued was that her charter rights were being infringed and her rights under the Bill of Rights were being infringed as a result of this requirement. Unfortunately, we were unsuccessful as the courts did not look at the charter test at all. They said that the charter doesn't even apply because this was a medical clinical decision by the doctors and AHS had nothing to do with it, even though this is an AHS program. And AHS in the evidence was implementing and requiring this COVID-19 vaccination according to the doctors themselves. So where we are today is that we have filed an application for leave to appeal to the Supreme Court of Canada. And I've learned a few days ago that the Supreme Court is actually looking at the case right now, and we should find out hopefully within a month or 2, but I'm not exactly sure, whether they want to hear her case. But what has happened in the meantime is that Sheila Lewis has received a kit in the mail from a lab in BC called Connexus, which is a very specialized lab. Dr. Stephen Pellick runs it, and he has undertaken a very detailed study into immunity from SARS-CoV-2, and she had her blood tested and sent the blood result back to him, and he assessed it, and a few weeks later came up with a report which identified that Sheila Annette Lewis actually had COVID twice. She had it once. He thought in September of 2021, and again more recently. And his report actually specifically identifies that in this trial that he's developed, and he actually had the results published in a peer-reviewed journal, scientific journal. He's found that immunity to SARS-CoV-2 lasts a minimum of 2 years. And so he said that her antibody level was extremely high. And so she is immune till at least this September and likely further from that point, because he said she's had it twice, once more recently than September of 2021. And so when we learned this, my client sent the test result to her doctors thinking, this is a game changer. They should allow her to have her transplant, because the whole point of the program, the whole point of the requirement in the program is so that, as in their own words, in their sworn evidence, they want to maximize the benefit of a scarce resource. They don't want their patients who receive a new organ to die of COVID. They don't want their patients in the hospital after they've had their transplant to transmit COVID to anyone else, to catch it there. And so the whole rationale is they're concerned about their transplant patients having a negative outcome from COVID-19. Well, she's got natural immunity. It's extremely high. And so there's no need now for a COVID-19 vaccine. And I was shocked when they responded saying, no, the requirement stands. You still have to get the COVID-19 vaccines. And because I've been working on this case for 2 years, and we've gone through cross-examinations of experts, the issue of natural immunity, although we didn't know that Sheila Lewis was naturally immune until recently, natural immunity came up, and we had two very experienced and well-respected immunologists in Canada write an expert report and testify that natural immunity is equal to or better than the immunity from a vaccine. It's long-lasting, and of course, you don't have any of the, once you've gone through COVID, and she has, you don't have to worry about any of the possible side effects from the vaccines. And so there's no reason now why they can't give her this surgery or put her back to the top of the list. And so it's really shocking. And what's even more astounding is that they've admitted in their sworn evidence and in cross-examination that they're willing to give a transplant to an unvaccinated person who has a medical exemption, such as an allergy to a vaccine ingredient. So let's get this straight. That unvaccinated person who may not have any natural immunity is allowed to get a transplant, catch COVID, die of COVID, all because they're allergic to a vaccine ingredient. But my client, who has extremely high antibody levels, is not. What's the point of this policy? And so there's really no scientific justification left whatsoever. I say that confidently because I know what my experts have said in this case, and I know what the experts on the other side have said. And they have, they called an expert in immunology who admitted that while natural immunity is transient, he said it does offer some protection. It's transient. He said he admitted so is the protection conferred by vaccines, the COVID vaccines. So if it's not because of science, what is the reason why they continue to deny my client life-saving surgery? It's really appalling.
I'm wondering what was in this reply that she received after she submitted her test. Did they give no reason at all, even if it wasn't scientific? Did they give any reason other than, bureaucratic sclerosis or something like that? Just like, this is the policy,
well,
that's it?
She first had I believe it was a Zoom conversation with her doctors, which she has been doing over the last couple of years. And she said, well, did you get my test result? Can you put me up, back to the top of the list, or in the high priority list, thinking that that's exactly what they would do. And because that's the logical thing to do in this case. And the response was, well, yeah, we saw your natural immunity test, and that's great, but I'm just paraphrasing, of course.
Sure.
I wasn't part of that conversation, but I've spoken with my client, and they told her, yeah, but you're only naturally immune for 2 years. And the doctor that she spoke to asserted to her that this Connexus report said she needed a booster, even though she has natural immunity. That is false. The report says nothing about a booster being required. And if you do the simple math, 2 years from September 2021 is September 2023. So she told them that she had natural immunity in March of 2023. That's, we've got April, May, June, July, August, September, 6 months at least of natural immunity, according to this report. And there was no indication that they're challenging the report or the validity of the report or the validity of the doctor who runs this lab. So what's the issue here? They're wasting time. They're wasting months. The right organ could come in the next few months while she has natural immunity. and they're just going to let her pass away, which is tragic, and it's absolutely horrific in this Canadian democracy that we have, or where we're supposed to respect and trust our medical institutions. And this is absolutely appalling.
And just to be clear, there were no reasons given for this other than it is the policy. That's what I want to just hear you
Yeah,
state.
the reason given was, well, you're only naturally immune for 2 years.
Okay, so they're
Right.
going to run out the
And
clock.
you
Okay.
will, according to this report, need a booster, which is false. So, she was very distraught over that conversation. And so she asked me to write a letter. So I sent a letter on her behalf, explaining to the doctors, in case they weren't aware, that in August of 2022, the Center for Disease Control in the United States actually publicly acknowledged the value of natural immunity to COVID in comparison to the vaccines. It said that because of infection-acquired immunity and COVID-19 vaccination, we've seen hospitalizations and long-term injuries from COVID decrease. And there's also a peer-reviewed study from one of the eminent scientific journals from February of 2023, which actually set out that natural immunity is actually stronger than the immunity from 2 COVID-19 vaccines. So the science is there. It's been there, acknowledged by mainstream CDC since last August, and yet they are refusing to accept her natural immunity. And in letters received back from the doctors, they said, we respectfully decline to reinstate you to status 2, and our policy remains. So there's no rationale and reasons given because there isn't a scientific rationale here. That's my conclusion. And so, we're left wondering how many other lives are going to be lost needlessly because of a policy that has completely lost its value for this patient and for other patients with natural immunity.
Has the timing of the pandemic factored into this at all? Because my understanding is that the threat level is a lot lower than when this case first started. And, the WHO has declared an end to it. And, of course, the provinces and the federal government no longer consider it an emergency. So are they claiming that the threat level is still the same? Is that the problem we have here? Or are they making no claim?
Well, that's an
on that?
interesting question, Kevin, because it's actually in the evidence in this case that Sheila Annette Lewis had a conversation with one of her transplant doctors in November of 2021, where they were going back and forth as to whether she would still be required to get the vaccine and would there ever be a time when she wouldn't need the vaccine. And he wrote in his medical notes that he told her that there was a possibility that the policy, their requirement, may be lifted once the pandemic is over. And of course, the WHO has now said that this is no longer an international emergency, and she's got natural immunity. And so, she's questioning now, what is the real reason why they won't give her the transplant? And that is a very concerning question in her mind.
Okay, let's move on to your grounds for appeal. Maybe you could tell us a little bit about that, your submission to the Supreme Court. What is your reasoning there?
Right. So we haven't actually fleshed out the specific grounds at this stage. What we had to do first was explain to the Supreme Court why they'd want to hear the case. And we have to put something together which explained why the case is of national importance. And it's really important in our view to get a ruling on whether doctors working within a provincial transplant program, and this could apply to other provincial medical programs, not just transplant program, and this could apply all over the country, not just here in Alberta, but whether doctors working within that program, and in this case they're independent contractors, whether they can escape charter scrutiny, because that's what they've done here. Is they've said, well, we're immune from the charter. We can do whatever we want because this is a clinical decision, and so you can't argue the charter. And we've also said, well, okay, this is AHS, then certainly AHS must be bound by the charter because AHS also has a vaccine requirement. That's in the evidence. And the courts have found, well, AHS was just following in the footsteps of the doctors. Therefore, they are also immune from charter scrutiny, which we cannot understand the legal rationale there because AHS is government. And there's no evidence that AHS's policy is exactly the same as the doctors. That was not in the evidence, but that's what the court found anyway, that it was exactly the same. So, we've got these important issues as to how do we look in Canada at the relationship between doctors working within a government medical program and patients' charter rights. Is this simply an issue of negligence and standard of care, which is what the lower courts have found? Or does AHS have a responsibility here? And do governments in general have a responsibility to make sure that when they hire doctors to work within their own, transplant programs or other healthcare programs, don't they have a responsibility to ensure that those doctors are respecting their patients' charter rights? Don't they have that responsibility? We say that they do. We say that this is different than if you go to your doctor and you say, I broke my leg, can you fix it? And the doctor does a poor job and doesn't fix it properly. That's not a charter issue. This is different because our argument is that this is a situation where we've got a transplant program, which is, taking a lot of patients, and they're putting forth a policy that applies to everybody, no matter your size, your weight. It's the same policy for everybody, patients they haven't even seen yet. Unlike a doctor who's seeing a patient in an office who's saying, well, you have these characteristics and you have this medical history, I'm going to prescribe you this drug. Or you don't need this drug because you've had a bad reaction to, something like that, where that's a clinical decision. So we want to have that conversation with the Supreme Court of Canada and really get them to weigh in on this notion of clinical decisions in a case like this, where this is within a government program, government-funded program for transplants, whether doctors are off the hook here when we're raising arguments under the Charter and the Bill of Rights of Alberta. And, what's one of our issues as well, and we've raised this within our application for leave to the Supreme Court, but we certainly will argue it as well as a ground of appeal, was that the Alberta Court of Appeal never in its decision never wrote any explanation or even mentioned my client's argument under the Alberta Bill of Rights. She pled not only the Charter, but she pled the Alberta Bill of Rights, and the Alberta Court of Appeal did not mention it, not even once. And we asked them respectfully by letter after the decision came out, could you just reopen this case simply for the reason that we're asking you to add further reasoning and add to your decision on this Alberta Bill of Rights issue? And they declined. And so, where is the analysis? We know when you plead a statute, you expect the court to engage in a well-reasoned legal analysis. Even if you lose, you want to know why. And so we're asking the Supreme Court of Canada to engage in that analysis for us. And so that'll be precedent setting for others who are interested in seeing whether the Alberta Bill of Rights protects their rights. And of course, it's analogous to the Canadian Bill of Rights in cases against the federal government. So, there are very important issues here that transcend simply this case. It's really the relationships between doctors, government, and patients within very specialized government healthcare programs.
Is it just specialized, though? Because one of the things that I heard you imply, anyway, what my interpretation was, that doctors will escape the charter simply because it is a medical issue, even though they are tied up in a government institution. Because it's a medical issue, it escapes the charter. And the implications, I'm thinking, well, a pandemic's a medical issue. Do they, by that same reasoning, escape the charter entirely? That's my trouble here. I'm worried that this could be expanded rather readily into other areas if they use a medical emergency as justification for impinging on charter rights.
Right. Well, I mean, you've got, in terms of the pandemic and public health orders, you've got chief public health officers, which are doctors, making public health orders under provincial statutes. So you can challenge their actions under the provincial statute. Here, you've got provincial statute in Alberta, which sets out that transplants are funded by the province, but the policy itself started out as a policy strictly that the doctors made, but then AHS started requiring the vaccines as well. So you've got, AHS, which is clearly government, then you have the doctors, and they both got policies. So the doctors are not acting under a statute to have their policy, unlike, the public health officers. But we're saying that regardless of whether you're looking at AHS's own vaccine policy or whether AHS has to be, looking at what the doctors are doing, it really shouldn't matter here. There is a charter issue because it's top down. AHS runs the show. They hire these doctors, and they cannot simply wash their hands and say, they can do what they want within our government transplant program. They can do whatever we want. We have nothing to do with it. And we want the Supreme Court of Canada to rule on that issue. It's very important.
Okay. How about colleges? How would they figure into this as well if a ruling came down that sided with? Are they considered quasi-government? Would they be affected by something like this, by the charter, or are they under other human rights legislation? I'm a bit concerned, like I say, about the broadness of the issue here.
The colleges of physicians and surgeons are they're a statutory body, so they are bound by the charter.
Okay.
Yeah.
Okay, good. All right, timing then. So we're, a couple of years into this already, and we're looking at how much longer before we hear back from the Supreme Court? Is this open-ended, or do we have something coming up right away?
Yeah, there's no set deadline for them. It's my understanding that once the panel is looking at the case, it'll be a month or 2 or 3 before they let us know that they're going to be rendering a decision in that regard. And there was just something else that I wanted to add as well that is really infuriating about this case. So many things is that Ms. Lewis actually asked her doctor twice in, I believe it was June 2022, to test her for natural immunity, to see if she had any antibodies in her blood. And in the first phone call, he said he would look into it for her. And then she didn't hear back from him, so she asked him again, and he said, well, we don't do that. And it was interesting. There was a witness at the National Citizens Inquiry who he's a paramedic for the province, and he testified under sworn evidence that he was let go temporarily from his paramedic position because he was unvaccinated. in, I believe it was in 2020, end of 2021. And he actually inquired with AHS as to, this is his evidence. He inquired as to whether he could be tested for natural immunity or whether he could go do it and provide them with the result. Would they accept it if he was naturally immune to COVID? And according to him, in his sworn evidence, someone at AHS told him that the lab is not allowed to test people to see if they're naturally immune.
There's a prohibition against it? Sorry?
That was his evidence.
Yeah. And you, of course, were at those hearings, right? You were in.
That's right.
Yeah.
Yeah.
Okay, I guess we can finish up by asking you about your client directly. Maybe you could just give us an indication how she's doing, emotionally, physically.
She's not doing well. For anyone who's interested, she actually testified at the National Citizens Inquiry yesterday, and I know that those hearings are available. If you're on Twitter and you go to the National Citizens Inquiry, you can watch it live. They have their own website, and after a couple of days, they post the whole day, so you can watch all of the witnesses. But she testified yesterday. She's not able to leave her home. She's got 2 oxygen tanks. It's very difficult for her to do anything right now. She can no longer, I understand she can no longer cook. No, it's hard for her to do anything around her house. And it's, it's very hard for her to function. And it's emotionally crippling to know that there's nothing scientifically standing in the way for her to have her life saved. She's in her 50s. She's got 4 children and grandchildren. And her life is slipping away from her for no good scientific reason. And she feels that, this kind of behavior from doctors who are supposed to look out for their patients, who are supposed to do no harm to their patients, is abhorrent and cruel. And it's really a black mark on our medical system. And, she and other Canadians who are in support of her, they feel shame for what's happening to her and other transplant patients.
Okay. Well, thanks so much, Allison, for bringing us up to date on that. I know this case is quite emotional and takes its toll on anybody that's working on it. So I commend you for working hard on this case on behalf of the Justice Center and Sheila. Thanks so much for participating in this episode of Justice Center Weekly, and hopefully we'll have you back again soon.
Thanks very much, Kevin.